My name is Andrew Bell. I work at Bradley, Aaron, Bolton Cummings, and I'm presenting today on Court Reporting 101, particularly avoiding pitfalls when scheduling depositions. I'm going to move on. So I'm going to provide you all with an overview of what we're going to discuss today in this CLE presentation. The topics that we're going to be discussing are on the screen. Particularly, we're going to be talking about what are certified shorthand court reporters and why it's important that you know this information in your practice. We're going to be discussing what the rules are applicable to court reporting companies and court reporters and why you as an attorney should take note of them. We're also going to discuss how you can prevent pitfalls in your practice and use court reporting rules defensively to your advantage. We're going to discuss the difference between digital reporters and court reporters and why it's important to know that distinction in your practice. And we're also going to discuss the admissibility of stenographic versus non-stenographic records and what you need to know about their admissibility. So I'm assuming that most of the people on this call attending are CLE. I'm assuming that most of the people on the CLE are young lawyers. This is, after all, a CLE presentation hosted by the Houston Young Lawyers Foundation. So with that in mind, I'm going to channel my inner days as a younger attorney. And I'm sorry, go ahead, Samantha-Anne, were you saying something?
No, I was not. Sorry, I logged in and didn't mean to interrupt.
Okay, yeah, no worries. So as I was saying, I'm going to channel my inner days as a younger attorney. I recall when I was a younger attorney being told to go on depositions, to attend depositions that were noticed by other parties or noticed by the partner, or using deposition transcripts after the depositions have already been conducted and noticed and taken by other partners. I would have never thought that the court reporter there hired to take down the transcript for the deposition had to be subject to certain rules implemented by the Texas Supreme Court and other agencies, and that the court reporting agency's failure to follow these rules could render the deposition transcript inadmissible. This is something I found out recently after COVID several years ago, and since then I've seen it pop up several times. So I wanted to go ahead and cover this with you all. The topics that we're going to cover in this presentation cover the rules. So while these topics admittedly seem very boring at first glance, they're actually very important, as knowledge of them could prevent you from having a summary judgment denied or evidence being ruled inadmissible at trial, which should be a red flag for most of you. So strap on and get ready for the wild ride of court reporting. So I want to start off the presentation with a hypothetical. Imagine you as a young lawyer are preparing to file a summary judgment motion. You know that what you have to do as part of that is to attach competent summary judgment evidence proven up by affidavits or unsworn declaration so that your evidence is admissible. Well, regarding the deposition transcripts of the parties, that typically is not a problem because typically you have a videographer there and you have a court reporter, and the court reporter is taking everything out stenographically and they're typing everything up so there's a record. And so you've spent the time and the money securing the deposition, scheduling the court reporter, the videographer, preparing for the deposition, traveling to the deposition, taking the deposition. You've spent all this time. And lucky for you, you've even obtained in the deposition the smoking gun testimony you need to prevail on summary judgment. Well, in preparing for your summary judgment motion, you rely on that deposition transcript you spent time and money to obtain. However, in response, you're hit with a hearsay objection or a motion to strike your evidence because the deposition transcript is inadmissible. And it boggles your mind because you're wondering, well, how could they say my deposition transcript was inadmissible if I hire a court reporter and they showed up and they typed everything down? Well, we're going to get into how that can happen here in a minute. And another aspect, another hypothetical I want to take you to is imagine later on, say there was no summary judgment motion filed and you got to trial. And you're trying to use this deposition transcript at trial to impeach your opponent's star witness, only to be met with an objection that the transcript is inadmissible hearsay. After arguing the point, the judge ultimately rules that the transcript cannot be used at trial for any purpose because it's inadmissible. That would certainly be a shock to you if at trial you want to impeach somebody and you can't use the transcript. So what's the culprit here? How can your deposition transcripts wind up being inadmissible? Well, the culprit is your court reporting company could have sent an unlicensed court reporter to transcribe the deposition. And in Texas, depositions must be taken by a licensed certified shorthand reporter, also abbreviated as CSRs, absent some limited circumstances, which we're going to discuss today. This CLE primarily focuses on this issue, particularly court reporting companies sending unlicensed court reporters to take depositions, as well as discusses a few other deposition scheduling issues, which you need to be on notice of as you're pursuing depositions. And so that leads me to a war story, which first brought me to this issue. So one time during trial, opposing counsel attempted to impeach our client with his own deposition transcript. The judge took it upon himself to first review the deposition transcript, fortunately, and after his review, he denied counsel the use of the deposition transcript for any purpose at all because it was not taken by a licensed certified shorthand reporter. Instead, it was taken by a digital reporter and notary public, which was improper. So the court reporting agency failed to follow the limited exceptions to the rule requiring the use of a non-certified shorthand reporter. And so they weren't able to use that deposition testimony at trial. And that was great for us because our witness did not get impeached. But it could have been something that hurt us in the long run if the tables were turned. So now we're going to get into what certified shorthand reporters are. In Texas, court reporters are supposed to be certified by the Texas Supreme Court as a certified shorthand reporter. Certified shorthand reporters, or CSRs, are trained and certified to accurately transcribe spoken words using stenographic means. And stenographic means it's essentially a stenographic machine that they use and they type on, and it's sort of like its own language in itself, but it transcribes whatever is being said in the room. So those interested in becoming a certified shorthand reporter must complete an application, pay a fee, pass a criminal background check, and also pass a CSR examination administered by what's called the Court Reporters Certification Board. And allowing non-certified shorthand reporters to transcribe your depositions not only prevents you from using that transcript at court, but also takes business away from those certified shorthand reporters that have jumped through all the hoops with the certifications and the background checks and the test administered by the state to obtain certification, and also who pay the fees associated with all those tests and the membership. Once court reporters pass their test, they receive a CSR number, which they can insert into any deposition transcript or include alongside their name. And this CSR number is very important, which we'll discuss later on. The Texas Office of Court Administration has a website on which you can go and you can see the credentials of any certified court reporter. So if you're unsure whether your court reporter is certified, you can get their name and you can plug them into the website to see if that's the case. And I've done that here, and I'll show you. Here's an example of one court reporter that I know is certified. You can type their name in. This is the Texas Office of Court Administration, and you can see she's a certified shorthand reporter. So this website could come in handy later on. So what rules govern certified shorthand reporters? That's section 154.101 of the Texas Civil Practice and Remedies Code. This section, particularly section A, states that a person may not be appointed an official court reporter or a deputy court reporter unless that person is certified as a shorthand reporter by the Texas Supreme Court. This is instrumentally important. Section B of 154.101 of the Texas Civil Practice and Remedies Code provides that a person may not even engage in shorthand reporting at all in this state unless that person is certified as a shorthand reporter by the Texas Supreme Court or an apprentice court reporter or provisional court reporter certified by the section. Additionally, section 154.101E of the Texas Civil Practice and Remedies Code provides that a person may not even assume or use the title or designation of court reporter, court recorder, shorthand reporter, or any abbreviation, title, designation, words, letters, sign, card, or device tending to indicate to any person that the court reporter is a shorthand court reporter, unless they're certified by the Texas Supreme Court. So this rule, a lot of people don't know, but it's very important when it comes to figuring out if your court reporter is a certified court reporter. You can't even use words or titles that would indicate that you are if you are not. So moving on, section 154.101 of the Texas Civil and Practice and Remedies Code provides that except in two limited circumstances, all depositions conducted in the state must be reported by a certified shorthand reporter. The two exceptions are very limited, and here they are. The first exception is the most important because it is the one that most often applies. The first exception is contained in section 154.112 of the Texas Civil Practice and Remedies Code. It provides that a person who is not certified as a court reporter may be employed to engage in shorthand reporting until a certified shorthand reporter is available. So in this situation, the certified shorthand reporter has to not be available, and then you can send somebody who's not certified. But to be able to serve as a shorthand reporter in that instance, the uncertified person has to do one thing or request that the parties do one thing. The first thing is deliver an affidavit to the parties. This is the uncertified reporter. They have to deliver an affidavit to the parties or their counsel before the deposition begins, stating that the certified shorthand reporter is not available for the deposition and that they're going to be taking the deposition in that person's stead. Now, after the deposition concludes and you have the transcript and it's been transcribed by the uncertified court reporter, that person must also file the affidavit with the court as part of the certification of the deposition transcript. So that is one thing that an uncertified court reporter must do in order to serve as a court reporter in that instance. The other thing that can be done is that the parties or their counsel must stipulate on the record at the beginning of the deposition that a certified shorthand reporter is not available. And again, these are two things that have to be done, but the key is that a certified shorthand reporter is not available at that time. The second exception to be aware of, which doesn't ever really come up, is section 20 of the Texas Civil Practice and Remedies Code. And that section concerns deposition on written questions, which can always be taken before a notary public because it's not a typical deposition with transcript and testimony being made. So there is something to be aware of. There are some court reporting agencies out there that have looked at these rules and have their way that they think that they can get around them and make sure that they can send uncertified court reporters. And so I provided an example of a notice that I've seen in some deposition notices that try to circumvent these rules. And I want to make everybody aware that some of these court reporting agencies merely advertise that including information in the deposition notice itself is sufficient to allow you to have a digital reporter rather than a court reporter. An example of this language is on the screen, and it provides, also take notice that we reserve the right to record the deposition either by stenographic means, by a court reporter certified to record depositions, or by non-stenographic means by a digital reporter utilizing state-of-the-art digital recording equipment. The testimony will be recorded by an official authorized to administer oath in the state of Texas. And so this is the type of notice you need to be aware of, because this notice, though it's important and it provides parties with notice that this is happening, doesn't comply with the rules. This is insufficient under section 154.112 of the Texas Civil Practice and Remedies Code. To permit a digital reporter, the certified shorthand reporter company the certified shorthand reporter must first be unavailable. Then an affidavit stating unavailability of the CSR must be delivered to counsel before the depot and subsequently filed, or the parties have to stipulate on the record to their unavailability. So this is something that's very important and to keep in mind as you're looking through deposition notices. Oop. So now I want to get into enforcement. There's a branch out there that deals with the enforcement of these rules, and that branch is called the Judicial Branch Certification Commission. This is the one that oversees the regulation and certification of court reporters. The commission can enforce section 154.101 by seeking an injunction against the individual acting as an uncertified court reporter, or by filing a complaint against the person who is not certified to be a court reporter. The commission is represented by the attorney general, the county or the district attorney, or counsel designated and empowered by the commission itself. The rules applicable to a court reporter are also applicable to the court reporting firm, which I found to be instrumentally important. So the commission can not only go after the person who was not certified, but also the court reporting firm. And what they do when they go after the court reporting firm themselves is they assess a reasonable fee against the court reporting firm for sending somebody who wasn't certified and failing to comply with the rules. Now, we mentioned the two exceptions to the rule of when you can send an uncertified court reporter to a deposition. Whenever that uncertified court reporter does not follow the rules, the commission can enforce that section by either collecting a civil penalty against the person. For example, they failed to file the affidavit after the deposition, or they didn't send an affidavit before the deposition. They can be assessed with a civil penalty not to exceed $1,000. They can also seek injunctive relief for a second or subsequent violation to prohibit that person from engaging in shorthand reporting in the future, unless that person subsequently gets certified. Importantly, also, the commission can recover attorney's fees and court costs in obtaining the civil penalty or injunction. So if you're ever subject to a court reporting company who sent an uncertified reporter there to transcribe a deposition, you can report it to the commission. And again, this is the Judicial Branch Certification Commission, and let them know this happened so that they can proceed with doing their civil penalties and injunctions and making sure this type of thing doesn't happen again to other parties. So there is one caveat to this rule that we've been talking about regarding uncertified court reporters. And it's important to note because some depositions don't just occur in Texas, they occur in other states or remotely in other states. Section 154.101 of the Texas Civil Practice and Remedies Code says that this section does not apply to court reporting services performed outside of Texas by a foreign shorthand reporter who is not certified in Texas for use in a court proceeding in Texas, provided that the work from those services is produced and billed wholly outside of Texas. Now, as with a lot of statutes that I've read, that is clear as mud. So I'm going to try and clear it up a little bit for you. Essentially, if you have a digital reporter or an uncertified court reporter who resides in another state and who is performing services outside of Texas in that state, example, they're providing services remotely, these rules do not apply so long as the work is produced and billed outside of Texas. And that is the kicker that you really have to pay attention to if you know that person is outside of Texas and doing their services outside of Texas. I've had to look at that issue with some court reporters that we've hired in the past. So on this screen are examples of court reporter certification that I wanted to show you guys in depositions that I've taken. On the left, you see a transcript and it says digital reporter and notary public. And on the right, you see one that says certified shorthand reporter. Now, regarding the war story that I mentioned earlier, the war story pertained to this deposition transcript on the left, where there was a digital reporter and notary public. The reporter certification shows the judge that the transcript is admissible if it's a certified shorthand reporter. Though it still does not contain the CSR's certification number here, it still provides evidence that this transcript is admissible. And again, if you're still unclear as to whether you can, or as to whether this person is actually a certified shorthand reporter, you can always look up on the Texas Office of Court Administration's website that person's name to figure it out. So with all that in mind, What do you do going forward? How can you use this proactively? And also, how can you use it defensively? So what do you do if after listening to this presentation, you realize you're going to trial and the deposition transcript in the case was certified by somebody other than an actual certified shorthand court reporter? Well, my advice is you just settle the case and do whatever the other side is asking. Just kidding. That's not the option. One option that you can do, which we've done in the past, is you can employ a certified shorthand reporter to retranscribe the deposition testimony. We've had to do this in one or two cases, and based on our experience, this is typically more costly than a deposition and takes more time than a deposition because it requires the court reporting company to review both the deposition video and transcript, then retranscribe the deposition testimony into an admissible transcript format, which the shorthand court reporter can then certify. So be sure to notify your clients of the increased cost if that's something that you're experiencing, and plan for the delay while the retranscription can be completed. In other words, this is likely not something you want to do on the eve of trial. So if after reviewing this PowerPoint, you want to go back and look at your deposition transcript reporter certification, it'd probably be a good idea just to be vigilant. And it's important to note that Rule 203.6 of the Texas Rules of Civil Procedure provides that the court reporter's transcription must be made from the original or certified copy of the deposition recording, and that the court reporter's certificate must include a statement that the transcript is a true record of the non-stenographic recording. So to the extent you do have to do this retranscription process, it's important to make sure that any court reporting company you hire to do the retranscription knows about these requirements. Otherwise, you might just end up in the same boat. And make sure you, your paralegal, or your legal assistant request that the court reporting company send a certified court reporter to the depositions whenever you're scheduling a deposition. It's an easy ask up front, and it can prevent a lot of headache later on. To cover your basis even further, you can also request that the court reporter provide their CSR number to you prior to the deposition, because typically a certain court reporter is scheduled for that deposition. You can email them and say, hey, can you please provide me with your CSR number? And if you are really paranoid to cover your bases, you can ask that the court reporter at the deposition, prior to it commencing, state that they are a certified shorthand reporter and ask that they provide you with their credentials. This may seem like overkill, but it's a lot safer and a lot less costly than having your transcript deemed inadmissible or your summary judgment denied. Also, if you find out that the court reporter is not certified at that deposition prior to it commencing, you would know how to proactively prevent any damage in the future. And that would be make sure there's a stipulation on the record in the deposition that a certified shorthand reporter is not available and that this other uncertified person is substituting in for the certified short reporter in its place if there was no affidavit provided beforehand. And it's also important to note proactively and to think about if the deposition is remote and the reporter is not certified, they told you that beforehand, you may not have to jump through any of these hoops if you just ask the court reporter, hey, where are you located? If the court reporter is located in Tennessee and they're doing their services from Tennessee and they bill you from Tennessee, well, then you fall under an exception to the rule. And you may not have to go through the hoops of an affidavit or a stipulation on the record. It's also important to know the state in which the lawsuit is pending, as some states have different rules regarding court reporters. Texas has their rule, which we've covered today, but other states have other rules regarding notice, regarding affidavits, regarding stipulations on the record. So it's important to know which state is this deposition and case pending in, and which rule am I subject to. Now that I've probably made you all fearful of who is recording your depositions and whether they're certified, I figured I would try to balance out some of that fear with a little bit of good news. And this is the nugget, which if you've stayed with me for this long will help you, I think, in your case. This knowledge of court reporters and certifications can be used defensively. For those of you who have logged into this recording, think about using this knowledge as a tool in defense of summary judgment. When opposing counsel attaches a deposition transcript to support the factual statements made in their traditional summary judgment motion, the first thing I always do is look at the court reporter's certification on the deposition transcript, if they included it in the record, to see if the person recording the deposition was a certified court reporter. And if they were not a certified court reporter, make sure that you object to the inclusion of that testimony as incompetent summary judgment evidence and move to strike it from the record or exclude it in its entirety. This would certainly catch opposing counsel off guard and could stymie them if they file their MSJ on the eve of the MSJ filing deadline. Now, the two reporter certification that I showed you 2 slides back, and I'll pull them up really quick. These 2 reporter certification, these beg the following question. What is the difference, and I'll go back, between a digital reporter in Notary Public and a certified shorthand reporter? And why would one be used over the other? I want to briefly discuss that and a couple of other things that flow from this, just so you guys are aware. There are distinct differences between court reporters and digital reporters. Court reporters are also known as stenographic court reporters, and they are the certified shorthand reporters that we've been talking about that are certified by the Texas Supreme Court, go through all the training, the background reports, and the tests. Court reporters use stenographic machines and shorthand to capture speech in real time. This allows the court reporters to create a verbatim transcript in real time immediately after a proceeding. Digital reporters, on the other hand, do not use stenographic means. They rely on audio recording equipment and specialized software to capture and transcribe the proceedings. The audio recording may just record a video and audio or just audio, but they don't necessarily always create a transcript like certified shorthand reporters do with their stenographic machines. Digital recorders record the proceedings digitally, either in person or remotely through Zoom, for example, but oftentimes this occurs remotely. And the recording is subsequently transcribed by a transcriptionist, and sometimes it's even transcribed through AI-powered speech-to-text software. So again, it's not the real-time reporting that you would see with a stenographer in their machine. So digital reporters have become prevalent in Texas, primarily starting during COVID. And what happened during COVID is that all the depositions that were scheduled were either canceled and then subsequently rescheduled through Zoom, and Zoom blew up during COVID. Because Zoom blew up during COVID, more and more remote depositions were being conducted remotely. With the strain of these increase of deposition requests through remote means, many court reporting companies did not have the staff to handle the rapid influx of requests for court reporters. And so what they were doing to cover their bases were sending out certified shorthand reporters, but also sometimes they would send out digital reporters or reporters who were not certified, and they would type up a transcript along with doing the video, even though they weren't certified to do it and they didn't meet any of the exceptions with the affidavit or the stipulation on the record. And so that's why this has become important over time and why I believe it's an important topic for people to be aware of. And with that in mind, it's important to note that it's only spring of 2025. We're 5 years after COVID started. I would say probably 3 years after it really slowed down. And some cases are still pending, and cases pen for years, and that could go back to 2023 or 2022. And so if that's you, that's a time frame when there was that increase of need for court reporters to do remote depositions. I would go back and I would double check to make sure that your firm or opposing counsel uses certified court reporters. Otherwise, you could potentially end up in a situation with regard to the admissibility of the transcript, either in a summary judgment motion or later on at trial. Now, when discussing certified shorthand reporters and digital reporters, it's important to know that digital reporters are not useless. And so we don't want to just dog on digital reporters. And that brings me to Rule 199 of the Texas Rules of Civil Procedure. Rule 199 of the Texas Rules of Civil Procedure states that testimony, objections, and other statements made during a deposition must be recorded at the time they are given or made. And so what digital reporters do is they record it through pretty much videography or something along those lines. This permits a party to cause a deposition to be recorded by means other than stenographic means, like video recording. Now, in order to do this, the party requesting the deposition and the recording by non-stenographic means has to, at least 5 days before the deposition takes place, provide notice to the other counsel that the recording is going to be non-stenographic. And this is usually done through a deposition notice. Typically, you'd see a deposition notice, and in the deposition notice, it would say this is being done non-stenographically. If the deposition notice does not contain that language, then the rule obligates you to provide that notice, perhaps via email or some other means, 5 days before the deposition. The notice has to state that the non-stenographic recording measure to be used is going to be X, whether that's a video or a voice recording, and whether the depo will also be recorded stenographically or not. And in response, what you can do if you see a deposition notice that says it's going to be recorded by non-stenographic means, you can serve a notice designating another method of recording. In other words, saying, hey, we want this to be done by stenographic means, which would then be done at your own expense. So I could see this be used on one side as a means to avoid cost and perhaps put the other side in a bind. It's definitely a strategy to think of, but digital reporters are used for this. But there is a difference between a digital record, a digital recorder just recording the deposition via video means, and a digital reporter recording the deposition via video means and also creating a transcript of the deposition. When the digital court reporter creates transcripts, this could potentially create an issue under Section 154 of the Texas Civil Practice and Remedies Code, like we've discussed. And to avoid that, the digital reporter would need to state that there is no certified shorthand reporter available, and to do the affidavit method or have the party stipulate on the record that this is what's happening. So I mentioned in the last slide a deposition notice that was done by non-stenographic means. I recently had one of those pop up, and so I thought it would be a good example to show you all. On the right-hand side of the screen here is a deposition notice that was issued in one of my cases. It provides that the deposition is going to be recorded by non-stenographic video recording and requires the other party to cross-notice the deposition to request a stenographic recording, which is what Rule 199 requires. And when you receive one of these notices, it begs the question of whether this deposition testimony taken by non-stenographic means is admissible testimony. Fortunately, Rule 203.6 of the Texas Rules of Civil Procedure answers this question. It provides that non-stenographic recording of an oral deposition or a written transcription of such a recording may be used to the same extent as a deposition taken by stenographic means. However, the rule does provide that for good cause shown, the court can require the party asking to use the non-stenographic recording for written transcription that they first complete a transcription of the deposition recording from a certified court reporter. So the non-stenographic recording is admissible, but the court could require that it be transcribed for good cause shown. Now, imagine you're opposing counsel in a case and you need to rely on deposition testimony to support your summary judgment. How might you go about using the non-stenographic recording? You can certainly try to transcribe it yourself and perhaps attach the non-stenographic video as support with the transcript, but this may raise questions as to its admissibility and may provoke objections from opposing counsel. And so it would be likely the safest option to employ a certified shorthand court reporter to transcribe the testimony so that you can use the certified transcript in support of your summary judgment motion. This would also likely be easier on the judge in reviewing your summary judgment motion, which could potentially increase your likelihood of it being granted. And with that, that concludes what I had to say about court reporters and why they need to be certified. I wanted to ask you all, instead of just being a purely webinar presentation, if you had any questions or any war stories regarding deposition noticing that you wanted to mention. And so with that, I'll open it up to the room.
They would have to put it in the chat.
Okay, if anybody wants to put it in the chat, we'll give a couple of minutes.
Great presentation, Andy, and the course number is listed on the chat as well.
And while everybody, if you have questions, is trying to put it in the chat, I do want to mention for the Houston Young Lawyers Foundation, we have some upcoming events that you wanted to be aware of. The first event is pickleball. That is happening on Saturday, April 26, 2025. This is one of those fundraising events that we're doing for the Houston Young Lawyers Foundation. Tickets are already on sale, so please sign up a team if you're interested in playing pickleball. It'll be a fun event. The other event we have is Law Day, and that is a very popular event. It's held on Thursday, May 1st, 2025. Tickets are on sale. If you want to purchase tickets for either Law Day or pickleball, please go onto the Houston Young Lawyers Foundation website. And then finally, last but not least, is the Fellows Luncheon. That is on Thursday, June 5th, 2025. So if you're a fellow and you want to hang out with some of the members of the board or other fellows, please save the date and attend this luncheon.
I'll do a personal plug and also a thanks to Andy for a really great CLE. If you are attending on our fellows luncheon and you would love to help us reach our goal of 25 new life fellows in 2025, you probably got an email from me this morning asking you to pay off your commitment. So we would love to be able to honor you there. But thanks again to Andy for taking the time to put this together. It was super informative. I think it's a great topic, and we've really enjoyed having him as a part of our CLE series this year.
Thank you all. I'll hang out for another couple of minutes. If you have any questions, add them in the chat.
But I retyped the number for the course number. It's on the chat. I think all the questions are asked.
Perfect. Okay.
I think I'll be fine.
Thank
We'll
you.
put
Appreciate
it
it,
on
Lizzie.
the website by Monday.
Okay.
Thank you. Have a safe day.
All right. Bye.
Bye.